Welcome to another Buildertrend webisode. Exciting stuff that we have for you this morning. It is the very first episode of our risk report card. I'm joined by Bill Gschwind of Minnesota Construction Law Services. We'll get to that here momentarily, but our first webisode is how to ace contracts. Before we even dive into the content, I want to give a little introduction of who you have on with you today. I am Knihnisky, Director Corporate Counsel at Buildertrend. You may have seen me a time or two on either a previous webisode or a podcast, particularly around the time of the PPP loans. I hope each and every single one of our listeners today are taking advantage of the information that we provided in that content. But as we turn the page and we hopefully are escaping out of COVIDia or COVID times, and we start turning to more traditional legal issues, I am being joined by Bill Gschwind of Minnesota Construction Law Services. He is the founder of Minnesota Construction Law. And Bill, tell us a little bit about yourself.
Hi, Nick. Well, first, I want to thank you very much for the opportunity to participate with you on the webisode today. I look forward to providing as much information as I can, things you asked for, helping all of the participants here today, those of you who are viewing the webisode, better understand the contracting process. We always say they call you contractors because everything you do involves a contract. So it's a pretty important, basic, fundamental document that should be a part of everything that you do. And we know in the good old days there was a lot of handshake stuff that went on, and lately there's been an explosion of lawyers, so there's been an explosion of contracts and the need to convert all those handshake agreements to written documents. So we want to help make that easier for the viewers today to understand, take some of the mystery out of contracting. My firm is a boutique law firm. We provide general counsel services to primarily owner-operated commercial and residential contractors. We certainly do a lot of the transactional work as far as drafting contracts. We help with the business side of the business as well as the construction side of the business. We provide additional services in relation to employment law, estate planning, pretty much any legal services that a contractor might need to run their business successfully is what we do. I have a lot of background as a business owner. I have an MBA. Did a lot of things outside of the law before I went into law. So we really work from the business side to try to help our clients sell more projects, make more money, and be more successful. So I look forward to the opportunity to help clarify this contracting thing and help your viewers better understand contracting so that they can do just that, sell more projects with contracts that are easy to understand and make more money by collecting for all the work that they do.
Yeah, that's a perfect synopsis, Bill. For me personally, I wanted to have Bill on because he's uniquely positioned for our audience. Like he mentioned, he's involved in the construction or the commercial and the residential construction spaces. He has some experience before his legal career, and these days he's boots on the ground. He's on the front lines representing contractors just like those that use Buildertrend. He has some firsthand experience of the common construction errors and pitfalls of the modern industry. And like you alluded to, it's become a litigious society. So we're happy to have you on, and I really appreciate you joining us.
Excellent. Well, let's dig in. It's a fun topic. Okay. For me, for the audience, maybe not so much fun. Maybe we'll take some of the mystery away and maybe make it a little bit more enjoyable for your viewers to understand the contracting process. So let's dig in.
There you go. Let's do it. And before we even get to the contract stuff, I want to give everybody a little bit of a preview for what our risk report card series is going to be. So over the coming months, I'm going to be joined by guests throughout the industry, not only residential construction, but we're also going to be looking at specialty and the various different elements that might play into the industry, whether it's insurance, whether it's dispute resolution, warranties, contracts, etc. When you come into the industry, and I imagine a lot of our viewers, they're not worried about the legal ramifications. Your job is to build a home, a roof, a swimming pool, etc. You're not worried about, and nor are you armed with the knowledge of drafting contracts, ensuring you have the right insurance coverages, or even protecting yourself long term. So that's where we're trying to help. Our goal is to approach risk and discuss how to approach risk in a way that you don't find yourself in that proverbial hot water. So with each new topic, like I mentioned, whether that's contracts, dispute resolution, insurance, etc., is going to include a webisode and then a variety of additional content surrounding it, specifically blog posts, checklists, and some of the other same things that are going to be elaborating on our topics that we're discussing in these webisodes. So as soon as this is posted, you should be able to go onto our resource library on buildertrend.com to access some of that additional material. I know we already have a couple blog posts in the works. Some of the information that Bill has provided with us, we've turned into additional written content that we hope will serve as a fantastic resource for you. Now, I should say, before we even get going, everything that we're telling you today is merely informational. You should not treat this as legal advice. If you are looking for advice on your particular situation, we ask that you consult individual counsel. Have to come off with that disclaimer. Otherwise, we would be remiss if we did not. So without further ado, let's get going and talking contracts. So agenda for this webisode, first up, why do you need a contract? Then we're going to turn to a few of the contract basics before we dive into a deep dive on the elements of a building agreement and what your contract should contain. So with that, let's get going. So Bill, right off the bat, I want to start with, why do people need a contract? Obviously, like we mentioned already, litigious society, putting things on paper is key today. Handshake agreements of the past, and Bill, you mentioned this right off the bat, are not going to work. So whether you're building a home, remodeling a kitchen, or any specialty job in between, you want to have a building agreement that outlines the services that you're going to be providing and the terms governing that work. But the big question that we hear all too often is, how do you build a contract that ultimately works for you and actually protects your rights? And that brings us to how we can choose a contract and some of the basics here. Bill, I know last month we were talking a little bit about templated agreements and the potential downfalls there. You had a really interesting perspective, and I'm kind of curious if you might be willing to share that now.
No, absolutely. The industry drafted template contracts are great places to start. But like any kind of a template, first off, they're going to carry the bias of the organization or the attorney that drafted the contract. So, the industry drafted ones that are most common that people hear about, AGC, the AIA contract, NAHB. AGC is the Association of General Contractors. Those are contractors that typically do large government projects, highway heavy types of work. So the kind of contract template that AGC is going to provide is going to be drafted with that kind of work in mind. AIA is the American Institute of Architects. They're going to be drafting a contract that favors the architects. AIA has done a great job of promoting their contracts, and you see them used quite a bit in large projects. But again, if you read through that contract, the architect is referred to as a decision maker and an authority figure throughout that contract. That's not necessarily the case with many of the viewers that are watching here who aren't building projects where architects are involved. The NAHB, National Association of Home Builders, again, that's a nice national contract that might work somewhere. It doesn't necessarily work for the specific contractor in a specific area. And one of the other problems with an industry drafted template is anytime you get to a template document that is drafted to be used by lots and lots of people in many, many situations, you generally are going to have a contract that isn't good for any one particular contractor on any one individual project. So you start grabbing these large template documents that are very well marketed, are understood by lots of different people, and working with them, you're going to have to take that template for each and every one of your projects and do an awful lot of whittling and changing of the language in that document to create an actual contract that's applicable to your company and your project. So you're generally better off, if you can, working with local legal counsel who understands the laws in your particular state to create a template document that you can use that reflects accurately the way you do business, the laws that are particular to your state, and the types of projects you typically build. You're going to have a different kind of a template for a new home being built on a lot that your buyer owns than you are going to have for a template on a remodeling project where you're doing a finishing project in a basement. And that's going to be different from a template that you would use, a contract you would use if you're building out a retail location in a strip mall. So template's a great idea. It saves money. It helps us use language that's been used before in other contracts so that we're not starting from scratch and creating an expensive document for you. But some of the big national, if you will, broad templates are oftentimes especially for smaller contractors building smaller projects, not a real good way to go.
Right. And for this industry where your client, this is typically a product or a service of work that is your client's biggest investment, right? And when you go in with a template agreement that you don't really know what it contains and you're just handing it over to them, you're leaving yourself really exposed, correct? And it's 100% worthwhile to go in on the front end, work with an attorney that's going to design a contract that fits your business and fits your needs, rather than just pulling something off the NAHB saying, yeah, this looks good, and handing it over to your client. That cost is insignificant compared to the potential ramifications down the line if things go awry.
No, that's very correct. And especially if you're doing residential contracting, most states have some kind of rules or regulations relating to the way that residential contracting is done. Very different than commercial. In our experience, most commercial contracting is still the wild, wild west. There's not a lot of governmental interference or dictates on what goes in the contracts or what the process is. But residential is a little bit more regulated most everywhere, and there's some requirements in almost every state for some particular language, maybe, whether it refers to mechanics liens or it refers to some kind of warranty obligations or maybe dispute resolution, whatever it is. Each state typically has its specific thing. So those are important. The other side of it is, from my world, maybe my past world, not as much the legal world, the contract document is a really important sales tool. And it's the document that you're asking your customers to sign, to review, and to solidify the relationship that you have with them for the project that's being built. And what you don't want to do is hand them a contract that is so difficult for them to read and understand, or for you as the contractor selling projects, you difficult to understand, that it becomes an obstacle to getting a signature and an obstacle to getting the project moving forward. So we want to make sure that the documents you're using are easy for people to read. And quite honestly, the AGC, AIA, even the NAHB contract, these are written by lawyers who are writing documents as lawyers, and they don't fully understand how important that is as a sales document. And the last thing you need to do is hand a contract to your customer who looks at it and says, I got to have my attorney review it before I can go ahead and sign it. Man, that's, you're stretching out the process and potentially ending up with, the sort of the battle of lawyers fighting over terminology in a contract. So getting something that's specifically created as a template for your projects really is going to make the process of selling projects better, and the process of explaining to your customers when you're sitting there talking to them what that contract says and what the terms of the deal are.
Yeah, and I think that's a perfect segue and to our next major slide here. And, in my opinion, this is the most important piece. If there's one takeaway today, it's that you need to know your contract. And Bill, I know it sounds easy that you should simply give your contract a look over, and especially if you've spent a couple $1,000s to have a private attorney draft something for you. But when we say knowing your contract, what do we really mean? It's not just handing over a piece of paper and saying, yeah, I worked with an attorney to draft this. It's actually knowing what's in that, right? And so that you can go to your client and you're saying this is a sale, kind of a sales pitch. There's an element of professionalism if you're able to explain some of the provisions that are in there. And we're not talking the deep legalese, but more so the services that are outlined and what that client needs to know, right?
Well, that's so true. And, I think one of the sort of the great fallacies that I think exists out there, lawyers have helped create this, and in some ways it's unfortunate, but part of what the general public believes is that the purpose of a contract is to protect the contractor. I really discourage anyone from thinking of a contract as something that's there to protect you. The more important thing is to look at the contract as the rules of your game. I like to do the analogy of playing the game of Monopoly. So you've got a set of rules in the game of Monopoly, and everyone's playing. You're rolling the dice. You're moving around the board, and one of the players lands on go. Now, everyone's played Monopoly, as some of you can remember. Think about this. So at go, I believe the square says pass go, collect $200. Well, you just landed on go. You are looking at your opponent who's at the beginning of the Broadway road, the fourth trail on that Monopoly game, and you would like to take that $200 because you needed to put a hotel on Boardwalk. And if you can get that hotel and hope that they hit it, you're going to collect a whole bunch more money. But the person who's going to roll next and might land on that square says, no, you have to pass go. You are on go. You have to pass go before you get your $200. And they don't want to give you the $200 because if you don't have it, you can't buy the hotel. What are the rules of the game? Let's make sure it's clear that there are no ambiguities, because that's when disputes arise later on. And that's when fights start, because when the situation arises and you're now trying to decide what the rule is, each of you is going to want to interpret that rule in the way that's most favorable to you, and we're going to end up with a dispute. So thinking of your contract as rules of the game, the way in which you are going to work and what's expected of you and what your homeowner is going to do, your customer is going to do, and what's expected of them, that should be laid out in that agreement. And if you don't understand what your contract says, and if you feel uncomfortable, and believe me, if your customer asks you a question about something that's in your contract, or you put it in front and say, here's what our lawyers are requiring us to get you to sign, and you're going to come across not knowing what's there. And if you don't know what's there, your customer is going to believe that there's a bunch of stuff in there that is not favorable to them, and they're not going to want to sign it until you either explain it or they get an attorney to explain it. So if you understand what's in your contract and you can explain a couple of provisions in there, you're going to diffuse that concern. It's going to be a lot easier to close the deal. And if you understand what's there, you're going to know whether this is the way you conduct business or not. And you're going to ask for changes to your template contract that's specific to your business before you're sitting down with the customer from your legal advisor. You're going to get a contract that works for you, and you're going to be a lot more comfortable yourself with the contract you're putting in front of people.
Absolutely. And that's our goal today, right? Is to provide at least some baseline informative resources or information that hopefully can allow you to approach those conversations either with your clients or, more importantly, with your legal advisor as you're approaching designing a new contract, whether that's leveraging a template or drafting from scratch. That's what we're hoping to do today. So that brings us right into what I'm going to call 202 of our webisode today. We have 101 with the basics and the intro there. This is the next level. We're kind of progressing along the way. So the elements of a building agreement, and these are the things that you are going to see in almost every construction contract. And we're going to touch on a lot of these momentarily. But when we talk acing your contract, it's having an agreement that contains each of these items. And I know it seems like a lot, it looks daunting, but when you're looking at a 7, 8, 9 page plus, obviously lawyers can get carried away with their language at times, but every contract's going to have these particular items in there. And so let's just jump right in. I figure that's the best way to go about this. Rather than listing all 14 items, we're going to cover each one in turn in varying levels of context. So going right off on it, state-specific required language. Bill, I know you've talked a little bit about this already. Is there anything more that we can follow up on? You've talked a little bit about mechanics liens and the right to payment. But what else are you looking at on the state-specific front, specifically as you are approaching? Obviously, you're out of Minnesota, but I know you do work in some other states on transaction contract drafting, right, so on and so forth. What are you looking at when you begin drafting outside of the state of Minnesota?
Well, let me first, before we dive into the specifics, let me just add one thing to what you're talking about with these 14 different items or so that you have listed here. Yes, they are all important issues to cover, and there are important topics to address, but there are various ways in which they can be addressed. And one of the things that we're careful of when we're drafting contracts is if you're drafting, if you're putting together a contract, you're putting a contract in front of your customer to do a $15,000 refresh on a bathroom. To give them a 20-page contract is probably going to be something you're not comfortable with, it's certainly going to be something your customer's not comfortable with. On the other hand, if you're doing a $350,000 addition to a home and you hand your customer a one-page contract front and back, they're probably going to look at you and it's going to look like you're maybe out of your league. So part of figuring out the puzzle of addressing all of these issues is understanding which ones are important and how do you address them in a reasonable way with the kind of project that's being done, so you're putting a document in front of your customers that isn't, again, intimidating and kind of matches the sale that you're doing. So with that said, we can take a look at the state-specific language. You're right, there's a variety of different rules in each individual state for the way that some of these different things are handled. We've got contractors who work in multiple states. They need to have a different contract for each state. You know, we all travel from one state to the other without even thinking that there's anything different. But when it comes to the legal side, moving from, you know, in our case, Minnesota to Wisconsin to Illinois, Iowa, the Dakotas, it's almost like going to a foreign country. It's a different place. And so you need different contracts, different language for each of those places you're going in a lot of cases. So you need to be working with a legal advisor that has an understanding of the projects that you do and then the language that's specific to that state, and be careful that you don't assume that because you can cross a border that a document you use in one state may be usable in the other. The delivery method, I don't think there's a lot that we need to kind of touch on there. Really, I think you're correct in that a lot of the projects that residential contractors are doing, and even some of the smaller commercial contractors, the contractor themselves, you know, there's not an architect involved. So, you know, whether it's design build or design bid build, you're going to end up with, you should have contracts anyway that reflect your project and sort of the rules of the game for the way that project is going to work.
Yeah, and I think this delivery method is, you know, one of the key components of, you know, potentially one of the downfalls of a templated agreement. You know, you go and pull the AIA agreement, it's essentially built around a design bid build mechanism, right? With the architect, as you mentioned, serving as the judge, jury, and executioner on everything related to the project. If you're not, you know, in a design bid build space, it doesn't make any sense to use the AIA template agreement.
Well, that's right. But, you know, for the contractor, and I assume most of the viewers are more contractors than they are architects, the real issue here is whether or not you can rely on the plans you're building from. And if there's a mistake in those plans, who's going to be responsible if you build according to the plan, but it turns out the design was wrong? And so if you're a design build contractor and you are doing design work, it would be a really good idea to talk to your insurance agent and make certain that the policy you have covers both the construction side of what you're doing, but also the design side of what you're doing. There may be some E&O insurance, some errors and omissions insurance that relate to the design work that is important, and there may be a different way you have to contract with your customer in order to make sure you've got the coverage that your design component works with. If you're in a design bid build where you're relying on somebody else's documents, you're going to want to make sure that in your contract there's language in there that indemnifies you from some of those errors and costs that might arise if it turns out that there's an error in the design. And that can go, we're going to talk about delays and some things in a little bit, but all of those things are important. So knowing what the relationships are and the documents you're relying on to do your construction is really the piece that's most important in that delivery method component of the contracting.
Yeah, absolutely. And obviously we'll get to indemnification here shortly, as well as touch on insurance. I know insurance is going to be a major webisode for us in the future, but that's really good advice on the E&O side. You know, covering yourself as much as humanly possible with insurance coverage is going to be critical in this space. So turning the page here to IDing key parties, and this seems like it should be a no-brainer, right? But I can't tell you how many times it comes up that we hear disputes about a homeowner being misidentified or not designating a specific communication partner with the homeowner, potentially not involving the lender at the correct stage. Lender learns about the agreement, you know, 90 days into the project and is like, wait a second, we're supposed to be delivering on our first draw request right now, and this is the first we're learning about any of it. So Bill, how often are you hearing anything on that side? And do you have any advice there?
You know, one of the things we always say about contracts is it's great to have all the information on paper, and they're really important. But you know what? If everybody can get together and play nice in the sandbox, and when the project is all over and done with, there's no disputes, everyone gets paid, everyone does their job, the contract really doesn't matter. It only matters when there ends up being something wrong later on, and by then it's often too late. So the biggest issue here that we typically run into with a homeowner project especially is that if you don't name both spouses and you don't have both spouses sign the contract and they're not paying later, and there ends up being a mechanics lien filed, and now you're going through the collections process, you're trying to foreclose on that mechanics lien. If you've only got one of the homeowners having signed and named in the contract, but both are owners of the property, you may well have a very difficult time foreclosing on that property and enforcing all of your collection rights. Because if one party owes money, the other party doesn't, and they both have an interest in the property, the courts are not going to give that property over to the creditor because they're taking away something that one of the owners of the property doesn't own. So that's one of the problems with it. The other, oftentimes you might be making improvements to a property that isn't actually owned by the people you're talking to. They could be tenants. They might be purchasing that home on a contract for deed. There might be a variety of ways in which the person you're talking to isn't really the owner of the property, which again makes it a little bit difficult down the road. And so, you know, making sure that you know who those people are is certainly important.
Yeah. And, you know, that brings us nicely over to something else that you had said earlier there, which is setting expectations. You know, the goal here is that the contract doesn't even matter. And how do you make sure that happens, right? And that's being transparent with your client, with everybody involved early on. You know, if you're able to set expectations, you know, specifically on the economics, everybody's always going to care, hey, how much am I getting paid? How much am I paying? So setting that out and saying, you know, let's define it. What is the total price? Do you have a draw schedule? Let's include it. Like I said, transparency is going to be key there. If you're setting those expectations on the front end, hopefully you're not running into any surprises on the back end, right?
No, that's absolutely correct. And I'm sure with every one of the projects, with every one of the viewers, there's an awful lot of stuff that's talked about from the time that first phone call came in, or that first door knock happened, or that first visit to a booth at a trade show happened. There's an awful lot of things that are talked about with this project. What's going to be done, who's going to do it, price, everything. The whole purpose of the contract is you're reducing all of those various discussions down to exactly what it was that everyone agreed to. And if it isn't written down, you know, my rule in law is if it isn't written down, it didn't happen. So you want to make certain that that contract has everything you want in it. And one of the keys here is that communication is a very, very difficult thing for most of us humans to do. We're really good at communicating out. We're really good at hearing. We're just not particularly good at hearing the same thing that the communicator is trying to tell us, or telling things in a way that the other person hears exactly what we're saying. So when you have to reduce that to writing, whether it's the parties, whether it's the terms, now you're both reading the same document and you can be certain that everybody's on the same page.
Yeah, and I think that's really good advice. And what you had said earlier there with, you know, the conversations along the way. And I'm going to skip number 5 here and come back to that because I think you segued really nicely to number 6, which is the list of documents that you should be including.
Mm-hmm.
You know, along the way, whether, you know, if it's a month-long process before deciding to get to the building agreement or a 6-month-long process, I'm sure there's going to be something else that you put on paper during that time period, whether that's a proposal, a bid, design documents. If you're going to intend to rely on those documents, mention them in the contract itself and saying, you know, here are the plans for the home, or here are the plans for the project, and incorporate those in there. Otherwise, they're just standalone, kind of off on an island sort of deal with no right to be governed by the terms of your building agreement itself, correct?
No, that's absolutely correct. And be specific, because we know that there are probably several sketches. There are multiple plans that have been done. There might be a couple of different sets of specifications, a couple of different bids. Make sure when you're identifying at the contracting stage, exactly which of the various bids, which of the various plans, identify them by a number, identify them by a date, but somehow make it really clear which of the construction documents that you intend on relying on to build the project is the one that you and the customer are both looking at and relying on. Make sure that that's really clear. We know it's going to change after, and I think we're going to touch on change orders in a bit. We know that those things are going to likely change later, but they're always going to be changing from that base point, and then you're going to document your changes going forward. So make sure you not only list the documents, but identify them somehow very clearly so that they're not confused with others that you may have had as part of the pre-contracting design discussions.
Yeah, shameless plug here. Our documenting feature of our platform really services nicely here. You can keep everything in one spot, present that to the homeowner so that they know, hey, here are the governing documents. Here's the bid that we're relying on. Here's the proposal that we're relying on. Here's our entire agreement, change orders, all in one place. That way there's no confusion about which version you're actually using, because Bill, to your point, you might have had various drawings along the way, and you never want to reach a point 6 months into the project where you're like, wait a second, that isn't exactly how we imagined. And, then you're looking at a dispute and you're staring it in the eye. So expectations are going to be the theme of this entire presentation, I feel like, which brings us next into the dates of commencement and completion. Bill, tell me a little bit about what you would recommend someone include in their dates of commencement and completion language.
My best advice, I assume that we're talking primarily to contractors, my best advice is don't get pinned down with a specific commencement date. Don't get pinned down with a specific completion date. Generally speaking, when you're building residential projects, you don't have customers who are relying on a grand opening date. You don't have people that are relying on moving dates as much. There's a little bit more flexibility in there. And you're also generally relying on people making selections at their convenience, trying to get deliveries of materials. And of course, now with what we've been experiencing through the COVID over the last 6-9 months, most everybody is having a real difficult time being able to rely on delivery of materials, being able to rely on the availability of labor. So pinning yourself down to a specific time for commencement and completion is difficult. Commencement is easier, and I can certainly understand putting something in a contract that says you're going to begin construction on a specific day. It's pretty easy to know that you can get an excavator there to start digging the basement. But committing to a completion date is much more difficult. We're not going to spend a lot of time on it here, but most of you have run into you'll see the term in typical contracts referring to a substantial completion date. It's a term of art in the law relating to construction. It has to do not when the project is completely completed, but when the project is completed to the point where it can be used for its intended purpose. Typically a CO, a certificate of occupancy is issued, or the person can start using the thing that you are building in the normal way. There might be some finishing things on there. So you want to kind of look at the way that you're talking about completion, substantial completion versus final completion. The one other thing that I'll mention, because it is here and it's really important, time is of the essence. That term that's in quotes on the slide here is a term of art in the law. Time is of the essence means that if you say the project is going to be done on August 23rd, then the project must be done on August 23rd. And if you finish it on August 24th, you've breached the contract. So be careful when you're looking at your contract templates, especially when you're pulling down some of these template documents that we talked about earlier. If you see that phrase, time is of the essence, understand that that's really important. That's key and probably a poison pill for most of you. And for the most part, I would not expect you as a contractor to want a time is of the essence clause in your contract. Homeowners might, or your buyer might, but I would do everything you can to keep that out.
Yeah, and we all like timelines and goal dates. But I was going to use the exact same term you just did, a poison pill or a drop dead date. And you're trying to avoid any situations in which you're pigeonholing yourself into something that you can't actually get done based on somebody else, on supply chains or somebody else's efforts that you can't guarantee on. So that's really, really good advice there. So turning the page, reps and warranties. That's looking at who does what. And again, this is where you can set expectations, obligations. What is the owner going to do? What are they going to provide? So Bill, you touched on this earlier, the legal description of property and why that's so important. You want to know who is on that deed, right? And who actually owns that specific property. Is it a couple? Is it just an individual? Because that's going to tie to your rights when it comes to actually collecting payment and enforcing a lien. What else here would you say are critical pieces to include on the owner's obligations?
To me, these are, this really is the most important, to me, part of the rules of the game. This is really the what I'm going to do and what you're going to do. And fundamentally, what it's saying is I, as the contractor, are going to build your project. You, as the homeowner, are going to pay me. And in that, as the contractor, I'm going to do everything I can to provide you with exactly what I tell you I'm going to build. And as the homeowner, you're going to do the things you need to do. One of the examples that we run into that really needs to be here from an owner's obligation standpoint is that they're going to make their selections timely, and they're going to get information to you. And if there are changes that are going to come up, they're going to let you know ahead of time. It's also really important, especially if you're doing the kind of a project that doesn't require, necessarily bank financing or a bank to be handling the money typically through a title company, through a bank disbursement of money based on pay requests. You want to know that the person who says they're going to be able to pay you has the ability to pay you. So provisions in that contract under the reps and warranties that say that they will provide the proof if necessary is important. Another is insurance. For the most part, if you're doing a remodeling project, any damage that occurs, any theft of materials from the job site, any weather that comes through and damages the project, those first initial claims are generally off of the homeowner's home policy, not necessarily off of your liability policy. So it's important to make certain, especially if you're doing additions to existing real estate, that you're requiring the owner to make certain that they have in place a homeowner's policy with sufficient limits on it to cover the cost of the finished project you're building. And if you're putting an addition on, obviously that could mean adding a lot of value to the policy for the home that's being built. So things like that are really important. Making sure that the owners understand what they're supposed to do. And of course, you're going to have some things in there that you're required to do.
That's interesting. And again, fantastic advice, especially the landscape of insurance and including those specific provisions. We're going to get to that here momentarily. And before we do, I want to touch on indemnification because you had mentioned this earlier. And Bill, this is one of those big, scary words in the contract space. You're looking at a list of form, legalese, language that really looks borderline Shakespearean. So when we're looking at an indemnification provision and we get overwhelmed by this big block of text, what should we be doing to actually, piece out different provisions that are going to cover us, or what should we be looking at when we're viewing those?
Yeah, this is going to be a tough one for most contractors. Indemnification, big word. Basically, what that means is that you're going to take responsibility for the costs that somebody else incurs as a result of this project in some fashion. There's a lot of different types of indemnification. You want to be held as narrowly as possible to be responsible for damages that your owner suffers, for example, during this project, but only for those things that are actually your fault, only for things that you did wrong. You don't want to be responsible for damages they suffer because of something they did wrong. You don't want your homeowner on a Saturday to be bringing their family over to look at the progress of the house and have the homeowner's child fall through a hole in the floor and be held accountable for that. And indemnification is the provision within your contract that controls that exposure that you have. So you want to be very careful. This is also the one place in a contract that you're trying to have drafted so that you understand it, your homeowner understands it, it's easy to read. Unfortunately, this is going to be that 12 or 14 line paragraph that is all one sentence that keeps having the if, thens, and what ifs and renaming of things. And it's going to be a very difficult provision. You're going to have to rely on your legal counsel to make sure that they help you know that this is a good provision, and maybe give you some tools for how to explain what this says to your homeowner. But really what this is designed to do is it gives your homeowner, your buyer, I say homeowner, but certainly it's the same if you're doing commercial contracting. It's the provision that tells the person that you're going to do work for that if I screw up on this project and it costs you money, I will stand behind that and I'll fill in that blank. I will take care of you.
Yeah. Yeah, this is where you designate liability. And, I know for me personally, it just makes sense to like put a bracket around the pieces that actually matter and what's actually being mentioned of, this is what we're on the hook for. Here's what you're on the hook for, because there's about 30 words typically before that of just like standard legalese of hold harmless and agree to indemnify and all sorts of other nonsense that still makes it difficult no matter how many contracts you've looked at. So hopefully, to your point, your legal counsel can advise or provide you with like a lay list of what's listed or provided in there or what's covered in there. And that should be able to help you translate that to your client, the homeowner, or whoever else is involved.
And I will add to that it's really important to have a well-drafted indemnification provision because it does serve a very valuable purpose. However, a lot of states now have laws in place to prevent you from making that provision so overly broad that not only are you maybe not responsible for anything, but you might actually make another party. In the old days, there's ways you can write an indemnification agreement so that if you're working as a contractor on the project and you fall down and get hurt, the homeowner indemnifies you against those injuries and the homeowner becomes responsible for paying for those damages. There's lots of ways to write this. So just want to be careful that it is narrow as it can be to protect whomever it is, typically the owner, from the things that you might do that you are responsible for and should have been more careful of so that they didn't have a problem.
So let's say you are on the hook for something via the indemnification clause or elsewhere.
Mm-hmm.
How do you cover that liability? In the best way, at least in my view, insurance, right? This is the magic word that you're going to hear about all along as a small business owner. Whether that's E&O coverage, general liability coverage, shameless plug for our BRI offering through Silverstone. If you're a home builder, please don't hesitate to reach out to Tony Ravenstall from our Silverstone team. He has some unbelievably competitive rates, I believe, right now. He should be able to help you lock in coverage if BRI is within your scope of necessary services. But otherwise, when you're looking at the requisite coverages, you want to have those listed, particularly if the homeowner is required to get anything, correct?
Well, that's correct. And the reality is your first line of protection, your first line of risk management in a construction project is your insurance. It's not your contract. It's your insurance. The second line is your contract. It's closely behind, but it's important because the contract has to be written in a way that your insurance policy is going to cover those risks that you carry. And the whole purpose of the contract is to make sure that you're operating and your customers are operating sort of within the protections that insurance provides, so that if something does go wrong, you or they have that bucket of money that's available to fix the thing that went wrong in the project. But there are always limitations to insurance. And one of the biggest limitations that as a contractor you need to understand is that there isn't an insurance policy that I'm aware of out there that's going to protect you from your own bad work. So if you build a roof incorrectly and that roof needs to be rebuilt, you're going to have to pay to have that roof rebuilt. Now, if it leaks water and there's damage on the inside of the home, your insurance policy might well cover what we call that incidental or consequential damage that results from the bad work. But insurance is not going to cover your work. And the other piece that's going to be important here for the viewers who are general contractors is to understand that when you hire a subcontractor, that subcontractor's work is considered your work from a legal perspective. And unless you have language in your contract, in your insurance contract, that provides coverage for you for the work of your subcontractors, you may be running naked in terms of and guaranteeing, if you will, standing behind being liable for the work that your subcontractors are doing, liable to your buyer for their work without having any insurance coverage to back that up. So be real careful when you're getting your insurance policies that you're getting insurance that from an agent and a company that understands what it means to be a general contractor and can give you good advice on full coverage. It's a very different policy than what the policy that your tile setter, for example, would have for that specific trade that they're performing for you.
And, you know, we fully intend to cover insurance, and Bill, you were alluding to this, warranties in a future webisode, because there is so much involved in that, whether it's the types of coverages, but also what are you on the hook for the warranty end? You know, as soon as you hand over that keys back to your client, what might you be liable for a call down the road? If it's that faulty roof, if it's, you know, substandard work, whatever it might be, you want to make sure you're covering yourself on that end as well. So there are just so many different components that are at play, and obviously the liability can be significant. So you want to make sure that you're not completely uncovered there.
So I think the one thing I would just add to this is that in the construction contract between the general contractor and the homeowner, you will oftentimes refer to your the contractor's general liability policy and work comp coverage and the ordinary business insurance that they're required to have. The piece that is sort of hinted at here that is also important to have in there is that your homeowner has coverage that the homeowner should be having that will relate to this project. And again, if it's new construction, typically there's going to need to be some sort of a builder's risk policy involved, because the contractor themselves is going to typically own the project until it's done. Yeah. If it's a remodeling project, it's more common that that project is owned by the homeowner, and their homeowner's insurance coverage is going to be primary for most of the kind of claims that can be made. So you want to make sure in that contract that there's language that the homeowner is maintaining a homeowner's policy in an amount sufficient to cover the finished value of the project being built.
Yeah, that's a really good point. So turn the page here, change order processes. And, you know, from my viewpoint, this is where we hear the major brunt of our disputes. You know, we have so many people that come to us and we're like, oh, you know, I thought we had a change order executed. I don't see it in our platform. What might have happened? You know, so on and so forth. And I think so many of these change orders are done via handshake agreements or via a call. It's just like, hey, you know, I want a different beam to be here, or I want the sink to be on the other side of the kitchen, or whatever change there might be. And nobody actually gets it on paper and gets both sides to sign it and include it in the contract. And it's unbelievable to me that that happens, because a change order is essentially an amendment to your contract. So you should have that on paper. Bill, to what you said earlier, if it's not on paper, it didn't happen. And change orders are the perfect example of this. So
well, I agree, and you know, and I know you say it surprises you, and it surprises me too, because you know we're both lawyers, we're document people. It
right.
doesn't surprise me that contractors fail to get change orders for a lot of the things that happen in the project, because contractors chose to be contractors to build stuff and not to play with paper. Yep. So it drives them crazy. Not only that, but homeowners will change their mind. Within talking about one change, they'll change your mind 3 or 4 different times. Yep. Plus, if you've got trades in there, you've got your homeowner talking to your electrician about adding a couple more outlets, and they don't really pay that much attention to what's going on. Or the plumber, they're asking for, you know, some other thing to be done with the plumbing. They're talking to your framer, and geez, what if you move the wall just a little bit? And you're hearing about all this as the general contractor well after it happened, and oftentimes not until you try to collect money for the additional work that was done. So this is, you're right, Nick, this is a very important component part of the construction project, because very, very seldom does it happen that a project gets built all the way through to the end without there being some sort of a change. And when that happens, having the change order is extremely important. And almost every contract has, in the boilerplate language, we're going to touch on that in a minute, every contract has language in there that says, this contract says everything that is to be said, and it cannot be changed without a written change order signed by everybody. And I'm sorry, you go up to a judge and ask a judge to make a homeowner pay for something that you built, that they asked you to build, but you don't have that signed change order. The judge is going to look at you and say, your contract says you wouldn't change anything without a written change order, and you don't have one. So guess what? I'm not making them pay you for it.
There you go. And Buildertrend offers a really fantastic change order mechanism. And, you know, if you plan to use Buildertrend, state that that's going to be the process in your contract and say, all change orders are going to be executed through BT. You can send them that document, have the client sign off on it, and send it back to you. And it's that simple. We can't recommend that enough. It goes, I mentioned that, I alluded to this earlier with the documents section within the platform. You can have everything right there as it relates to the job, and it's so accessible. And pull up any change orders, what the amendments to the agreement are, what actually applies to the job, and it's all right there in one easy to access space. Is there anything else I missed there, Bill?
Yeah, I think there's a couple of other very helpful things that we can add to this. First off, a change order does not necessarily have to be signed before the change is performed. It's best if it is. It's best if you have that agreement. But if you get the thing signed later, just saying, this is what we agreed to, this is what we did, you sign off on it, that's wonderful. That still is it's an enforceable change order, and it shows that there was an agreement. It's also can oftentimes happen that the change can be made faster than you can calculate all the changes in price, for example. So you can have a change order that generally says the homeowner is agreeing to have us make this change. Put it on a napkin, put it on anything, get something that is signed so that you've got that. You can always come back later and fill it in. And here's the other piece. In your contract itself, there should be a provision about the way change orders work that says that if the change order is signed and there wasn't a price at the time the change order was signed, that the parties will agree to a price later. And if they can't agree later on a price, then there's a mechanism, a formula built right into your contract that says how that change will be priced. So that, and typically it's going to be you're going to provide the cost that it took to put that change order in place, and then some kind of an upcharge for profit and overhead and some of the unknown costs. So this is really an important component part. It can be handled well. It should be documented well. It doesn't have to get in the way of the fast changes that typically occur in a construction project. Just make sure that you've got a process in-house, and that Buildertrend offers a good one to use is wonderful. It still requires you as humans to either push the right buttons or do the things that it requires to be done as part of that process. But this is really a key piece, and you're right, Nick. This is probably the area where the most disputes arise, and the most expensive. You end up walking away from an awful lot of change orders because the process of resolving the dispute is more expensive than the cost of the change.
And I know, Bill, we've had some recent conversations about this same topic, and if you're up for it, I'd love to bring you back on to discuss dispute resolutions down the road, because I think we could easily cover 45 minutes on just dispute resolution and everything involved there, especially in the modern age where we're hearing about arbitration. There's, I know the NAHB kind of pushes for arbitration, and I know you have a very interesting perspective there that I'd love to bring you back on for, and we do a deep dive there. So if you're up for it, I'm going to make you commit right now on air.
Absolutely. Love to.
All right, that sounds great. So moving back to termination and suspension. So tell me a little bit about what we're looking at here, Bill. So, you're looking at termination for cause, for convenience. At what point can you walk off the job site?
Yeah, this is really, really key. And the first thing that people need to understand, the contractor and the buyer, is that when two parties enter into a contract, neither party has the right to walk away or change that contract without the agreement of the other side. And so one of the things that we, certainly if one of the parties is not doing what they're supposed to, they're not following the rules, they're breaching the contract is the legal term, the other party may not have an obligation to continue with their duties under that contract. It doesn't mean they may, it doesn't mean that just because somebody doesn't pay you when they're supposed to pay you, that you have the right to walk off the job. There has to be language in the contract that addresses that particular circumstance. So cause, when we say for cause, that generally means somebody did something wrong, and is the thing they did so egregious, so bad, that I can just walk away and be done with this contract. Termination for convenience, for all intents and purposes, that just simply means that one of the parties really doesn't have to abide by the contract if they don't want to. That's what that means. And we oftentimes see language in contracts that gives the owner, the buyer, the customer of the general contractor, gives the owner to wake up one morning and say, you know what, Never mind. My brother-in-law can do the rest of this project and save me a bunch of money. So I get to terminate the contract for my convenience. I'll pay you for the work you've done, but I don't owe you anything more. And, if you're a general contractor, you didn't take a bunch of other projects or go out and try to find a bunch of other projects during the time you were going to be building this one because you had your resources used up. And so if someone just throws you off the job site, you're not only out the balance of the money that you should be paid, but you don't have another project to fill in that gap. So you're out twice potentially. So we don't like termination for convenience clauses in contracts. We like to make sure that they're out of there. And that's the biggest one. And this termination without a legal right, again, typically a contract for most residential purchases will have some sort of a provision, that sort of a right of rescission, a rest period, 3 days that you can change your mind and get out of the contract. But without a legal right to terminate, we're talking about that kind of a provision in the contract that gives somebody the right to get out. But once that time has passed, they can't back out anymore. Contingency is another term that you'll oftentimes see in new construction, a new home. It's not uncommon to have a contingency clause in the contract that says someone can get out if they can't get financing, or they can get out if their home doesn't sell. Those are the legal right to terminate a contract. And you want to make sure when you're looking at your contract, from my perspective, I wouldn't be giving my customer a whole lot of legal rights to back out of a contract, or I at least wouldn't start building until I knew that a lot of those legal rights had already passed.
Yeah, and that's really, really interesting advice because, to your point, you don't want to pigeonhole yourself into something that you don't actually want to complete the work on. And your job is to get paid at the end of the day. You're running a business. You want to make sure that you're putting yourself in a position that if you do have to terminate, and hopefully that's never a case, that you have some kind of recourse to continue cash flow to your business and get either return to the job, get a new job, have some kind of ability to recover or recoup the lost costs. That's right. So all very interesting advice, Bill. Bring us to the last slide here. The party's almost over, Bill. So you mentioned a little bit about this on the boilerplate clauses, specifically the merger clause you had discussed earlier, where everything that's included in the contract is the contract, and there's nothing outside of that we're going to consider. If you don't have a change order that's amending the contract, then it's not part of the contract and you have no right to enforce it. Some of these other boilerplate clauses, and oftentimes you'll see these just in a big block at the end of the contract. What should you be looking for, or what really stands out? We're not going to worry too much about governing law that you would typically see, because I'm assuming your local state's law is going to apply 10 times out of 10 for the most part. Sure. But other than that, what should we be looking for?
Nick, I think the most important thing for your viewers to understand is that boilerplate clauses are oftentimes not paid attention to because they're assumed to be just a bunch of legalese that's thrown at the end of a contract that just needs to be there, but it's not really as important as all of these other clauses that appear earlier, typically in the contract. Nothing could be further from the truth. All this means is that there are some very specific provisions that are inside that contract that are the same with every contract and rarely change. And they're very important. That merger clause, that all that says is, it doesn't matter what we talked about before. If it's not in this contract, it's not a part of the deal. So we're going to put a merger clause in there. If that merger clause wasn't there, then when you had that very first conversation with the homeowner where they said, we're thinking about putting on a shed in the back of the yard when you're all done, and you mentioned, would you build that for free? And you tell them, yeah, well, if we get the deal, we'll put a shed back there. You guys go through all your conversations, and by the time you're done, the shed is no longer a part of the deal. If that merger clause wasn't there, your homeowner is going to come back later and be very likely entitled to a free shed. So clauses like that are really important. Legal fees is also a very important provision in these boilerplate clauses. In America, everybody pays their own legal fees. So whether you win or you lose, you pay your own lawyers. That's a huge deal because legal expenses can become so expensive. If somebody's making a frivolous claim against you and you win, it might cost you more money to defend that claim than it does to just give them what they're asking for. So having a provision in your contract that that entitles a winner to get their legal fees paid is important. And there's a number of those in here that are key. So the boilerplate clauses are important. You want to know what they are and understand what they mean. Don't just accept them because they're in a template contract or they're in a contract that you got from your buddy, the contractor, and he got it from his buddy who got it from a lawyer. So it must be good. Don't rely on that kind of stuff. Know what's in there. The force majeure clauses are really, the concept here is that there are things that are outside of your control that can happen during a project, and you shouldn't be held accountable for those. The homeowner is going to have to bear the brunt of those. Again, this is really important, and you have to understand what they mean and what they're restricted to. So in my state, for example, we have winters, and during the winter, we're going to have inclement weather, and we're going to have snowstorms. A snowstorm is an act of God. However, because you're building in Minnesota and you know we have winters and you know that it can happen, that we can get a snowstorm that might prevent you from being able to work on a project, means that it's not going to be an excusable delay if we get a snowstorm that prevents you from working on the project, because that's something that you knew, something you should have built into your plan. I think the COVID right now is one of those areas where when it first hit, it was most likely would fall in as a force majeure event. But now we know COVID is here. We know delays can be caused by COVID. We know that there can be flares. We know that it might be difficult to get product. So I think it's, we're going to have a lot of lawsuits that are going to tail on here for quite a few years to get some of this cleared up. But I would encourage all of you out there that are viewing this, don't think of issues related to COVID as going to be falling into the force majeure, and you're not going to be responsible for delays caused by that. Either write specifically in that you're agreeing that a COVID-related delay is not going to be your responsibility, or take the risk of knowing that it's not there. But this is, again, one of those really important provisions to understand what's there and have someone who can help you on the legal side make sure that whatever you think should be falling in there is, and it's got to be really carefully drafted.
Bill, I think that's a really great distinction that you made in Minnesota with the weather. Typically there's going to be large weather events, floods, tornadoes, natural disasters that are going to fall into a force majeure. And it comes back to the concept of foreseeability. Could you have foreseen that weather event was going to take place? In Minnesota in January, probably going to get some snow, right? Pretty easy to say that one's going to happen. And nowadays with COVID, it's the reality today that there are going to be those spikes, and potentially you might have contact tracing that leads to your subs or some of your other employees being kicked off the job site, and what's going to happen there. So considering all of these different elements is so key, and bringing these to an expert that knows what in the world they're talking about is so important. If we're going to take one thing away today, it's to consult with a legal expert, make sure you guys are on the same page, have them design a contract that works for you. Now, Bill, let's say I'm trying to reach out to you to have you design a contract for me. How can I get a hold of you? What's the best way to go about that? What can I walk in the door with?
Sure. Our main offices are in the Twin Cities, Minneapolis, St. Paul area. We also have offices outstate. So any of those we can be reached at through the same email address or the same phone number. So as you see on the screen, my email address is bill@mncls.com. Drop me an email anytime. I'm more than happy to answer what I can, or at least help steer you in the right direction. And you can also reach us at 651-484-4412. And again, our phone system is set up so wherever I am, wherever the other attorneys in the firm are, that number will get you to us. We're more than happy to help where we can.
And just to clear it up, I don't need to be in Minnesota to use your services, correct?
Some of those services, that's correct. We certainly, lawyers need to be licensed in the state in which they're doing work. So there are some things we can do. We have clients who are doing construction in multiple states, and we can certainly draft documents for them, help them prepare contracts for those other states. But if a dispute arises in another state, we do have to be licensed in order to appear in the courts of those other states. We can either, there's ways that lawyers have to either work with other lawyers in other states, or ourselves to be able to represent in other states when we're not licensed there. So there's ways to work around those things, but local counsel is generally going to be the best ones able to help with the things that are going on in their particular state. We are licensed in Minnesota and Wisconsin. Those are the states that we do most of our work in, but we do have clients in almost all the other states in the country where we have helped them. They're based here, they're doing work in other states, and we can help with that.
Great. Well, Bill, thank you so much for joining me today. This has been a ton of incredible advice. I know we're looking at just over an hour at this point. I don't think I want to cut any of it off because I think everything that you were sharing with us today is critical for any contractor, specialty, whatever you're doing out there. These elements of a contract are so vitally important. And Bill, I can't thank you enough for joining us. What you said was really impactful, and hopefully it's going to be able to help out anybody that tuned in today.
Nick, I appreciate the opportunity. Thanks very much, and look forward to helping anywhere I can.
Yeah, we will be in touch ahead of the dispute resolution mechanism webisode, so stay tuned for that. Bill will be back on, and can't wait to talk about it.
Excellent. Thanks, Nick. Bye, everybody.
Thank you, guys. Have a good one.